Assalamualaikum and hi everyone. I am Wai, your host for our discussion on legal framework and Shariah issues in Ibra. So in this video, we will discuss Ibra and some application in financing activities. We also will discuss the legal aspects and issues faced by the Islamic banks related to Ibra. Before that, let me explain about the Ibra. Ibra is defined as a rebate granted to customers who made early repayment on financing. Technically, Ibra or rebate is given by the Islamic banks to the customers who settled the payment within the installment period or earlier. So Ibra gives benefits for both Islamic banks and customers. For Islamic banks, it encourages its customers to make early payment, lessen the potential of default, and be competitive with conventional banks. On the other hand, the customers will gain benefits in terms of reduction of total amount of financing and create a good credit rating. Next, in Shariah rulings, Ibra is recommended as it encourages the creditors to help the debtor who is having difficulties in repaying the debt. Even if the debtor is not having difficulties in repaying the debt, Ibra is still recommended as it can develop the relationship of trust and friendship between the creditor and the debtor. So Allah Subhanahu wa Taala had mentioned in Holy Quran at the following, and if the debtor is in difficulty, grant him time until it's easy for him to repay. But if he remit it by way of charity, that is the best for you if only you only know. Surah Al-Baqarah 200 verse 280. So that's little bit for Ibra. Now let's look on the legal requirement regarding to Ibra. Currently, we have come up with two lawyers, Mrs. Shariah and Mrs. Fahimah, and another two bankers, Mr. Luqman and Mrs. Adlina. So, Mrs. Shariah, is there any legal requirement related to Ibra?
Assalamualaikum warahmatullahi wabarakatuh, everyone. I am Shahira, lawyer from Azmi and Associates. Thank you to Mr. Wai for inviting me today. So we will now talk about the legal requirements that has been issued by the Shariah Advisory Council of the Bank Negara Malaysia. So there are several resolutions that have been issued from the year 2000 until 2010. So in the 101st meeting of the SAC in 2010, it was decided by the SAC that the Bank Negara may order Islamic financial institutions to grant Ibra to customers who successfully fulfilled their debt obligations that derive from the sale-based contract prior to the settlement date that is agreed upon. Other than that, there is also another resolution that is made to prevent any ambiguity about a customer's eligibility to receive Ibra from an Islamic bank. The terms and conditions on Ibra must be integrated into the financing agreement before the final agreement is made. And all the formulas of Ibra will be standardized by Bank Negara Malaysia. Other than the legal requirements, we should also look into its Shariah requirements to understand Ibra further. So the guideline on Ibra that is provided by BNM shall be applied to all financing based on sale contracts such as Murabahah and by Bisamanil Azil, but there's also other contracts like Salam and Istisna that requires a different treatment. Therefore, Ibra is not applicable to those contracts. And as a sale-based financing contract should include fixed rate and also floating rates structures in their contract. It also prevents the contracts from being associated with gharar and riba, as it is known that gharar and riba should be avoided in business transactions to whatever it takes. And this brought us to another point of Ibra being favorable to the customer's maslahah, as it is established transparency between Islamic banks and their customers. So yeah, that's all from me. Going back to our speaker.
Okay, thank you to Mrs. Shahira. Next, Mrs. Fahimah, can you explain about the operational requirement in Ibra? So please welcome.
Okay, thank you so much for inviting me into this talk. Assalamualaikum warahmatullahi wabarakatuh. My name is Fahimah binti Md Radzar, a representative from Kamal and Partners firm. So to understand more about Ibra, we need to understand its operational requirement. First, all Islamic finance institutions are required to grant Ibra for the customer that has settled their financing before the end of the settlement date. Then, by using the variable rate financing concept, we will look into the difference between the amount of profit calculated based on the ceiling profit rate, CPR, and effective profit rate, EPR. If the EPR is lower than the CPR, then the customer will get an Ibra. Furthermore, to ensure the legality of Ibra, All Islamic finance institutions must explain clearly to their customer and provide related documents such as offer letter and other legal documentation related to the sale-based financing. And they also must highlight the clause on the commitment to obtain Ibra. Other than that, the granting of Ibra can be more than the total amount of outstanding financing or selling price to the customer. However, due to the early settlement upon the maturity date, the Islamic finance institutions are expected to cover the cost of purchase or the principal of financing. Hence, the Ibra will come from the deferred profit. So I hope that I clearly explained to all of you. So I pass back to the host.
Okay, thank you, Mrs. Fahimah, for the explanation. So next, we can proceed to both our bankers, which is Mr. Luqman and Mrs. Adlina. So so the first, Mr. Luqman, how Ibra is work? Can you explain the operation and application of Ibra in Islamic financial institution, please?
Okay, Assalamualaikum. Thank you to our host today. Here I will explain some practices in financing by banks in Malaysia. So we take Bank Rakyat and Bank Islam as our examples. Bank Rakyat incorporates Ibra clause in every financing legal agreement in order to eliminate any uncertainties with regards to its customers' rights. So Ibra is calculated by taking deferred profit plus any undisbursed principal amount minus other charges. So Bank Islam also applies Ibra, which in case of early settlement for financing contracts, they take computation part, which Ibra is equivalent to deferred profit at the point of settlement. So deferred profit is derived by computing total contracted profit minus accrued profit. So that is the two examples of Ibra application in Islamic banking institution in Malaysia. Thank you.
Okay, Mr. Luqman, thank you. So next, our last speaker, Mrs. Adlina. So can you explain what is the issues in Ibra by sharing some gap analysis or some issues in our society? Please welcome.
All right, thank you, host. First and foremost, gap analysis is when the actual performance in the industry is compared to the desired performance. So here our desired performance is of course the Shariah principle related to Ibra, whereas the actual performance of Ibra in the industry will be explored in two perspectives. Those are society's perception of Ibra applied by the banks before the regulation set by the NM, and on the other hand, the implementation of Ibra in banks after the regulations set by the NM. So before the regulations, society's impression on Ibra was largely that Islamic financing products related to Ibra are excessive and oppressive due to several court cases between Islamic banks and their clients. Aside from that, the lack of proper SOP by the Islamic banks on the application of Ibra or rebates also contribute to the negative image on Islamic financing products. Thus, from the perspective of Islamic banks, the regulation by the NM is then deemed necessary in the contemporary Islamic financial scene in order to bring maslahah to both Islamic banks and their customers, as well as to harmonize between regulation and reality of the current financial situation. Aside from that, the regulation is also important in order to avoid horror or uncertainties in determining contract price. So looking through the Shariah perspective, the confusion surrounding the topic of Ibra emerges in part due to the differences of opinion amongst Islamic scholars on the implementation of Ibra as outlined by the regulations issued by the NM. Some scholars opine that the regulations by the NM takes away from the elements of charity and tabarruk or voluntarily associated with Ibra, and traditionally, Ibra should be granted on the principal borrowed instead of the profit that the bank may gain. So comparing from these two, from my perspective, the special regulation issued by the NM on Ibra, although necessary, should not be the end-all be-all. Shariah advisors and scholars must look for better alternatives to ensure that the application of Ibra is as outlined by the teachings of Shariah. Perhaps the use of Ibra in financing should be reduced and better Islamic finance contracts should be used in its place instead, in order to streamline the Islamic financial system to be truly in line with the principles and teachings of Shariah, while also realistically corresponding to the reality of the current financial environment. This is also important to remove confusions and misconceptions on Islamic financing products. That's all from me. Back to you.
Now, here comes the end of our topic for legal framework and Sharia issues in Ibra. We have discussed this topic from its background until the gap analysis. Hope that everyone can understand our topic for today. Stay tuned for our next talk. Wabillahi taufiq wa hidayah. Wassalamualaikum warahmatullahi wabarakatuh.